for right now, we're going to move over to the situation when a single person dies and they did not have a will. Okay, so are you married? No. I'll point out here when it says, are you married? Is the deceased person married? No, they weren't married. So then the next question that is going to be asked is, well, were there any kids or grandkids, descendants? I mean, that could go down to kids, grandkids, great-grandkids. Just think of descendants, people who are of the same bloodline, children of various, generations. So, okay, single person dies and they have kids or grandkids or great-grandkids. Then 100% of that estate goes to your descendants. So in that situation, let's say the deceased person had 4 kids and they're all living. Those 4 kids all get 25% of the estate. Let's say that of those 4 kids, 3 are living and 1 is deceased. So for that deceased child, their children step up to inherit that quarter of the estate. So if the deceased kid had 4 kids, they will all get 1/16 of the estate, and the 3 surviving kids all get 1/4, 1/4, 1/4. So it adds up to 100%. Who is a child? Who is a descendant? That is somebody who is either legally adopted or biologically related to the deceased person. It doesn't have to be, it can be the siblings can be half siblings, for example. That doesn't matter. It simply has to be a biological descendant of the deceased person or an adopted child of the deceased person. So what the state of Washington is trying to do here is they are trying to come up with a plan for the person without a will that would reflect what they might want. And if you're a single person and you have kids, presumably you want your kids or grandkids to inherit from you all equally. If you actually wanted to disinherit one of your children, you need a will. If you don't have a will, you are not disinheriting that person. They will inherit an equal share along with your other kids. So one more reason to have a will: if you want to disinherit somebody, you need to have a will to do that.